group CEO. With regards to the operational strategies, he stated that they were embedded and domiciled with the operating companies and subsidiaries of the claimant, such as Avant Halogen, Avet Halogen, Academy Halogen, and PSM Halogen. It is his defense that these subsidiaries were responsible for the execution and implementation of all the business and divulged from the group CEO through the office of the CEO and the project management office, the PMO. Furthermore, he stated that by the tiered structure of the claimant company, he did not occupy or head any of those offices throughout his employment with the claimant, and he was not the custodian of the claimant's alleged strategic business plan of 2020 to 2027, customer database, strategic cutting-edge methods, plans, market survey reports, pricing methods, and operational modules, as well as the database of the claimant's alleged local and international partners. In addition, the defendant stated that the claimant's official files, documentations, plans, policies were all domiciled in the corporate archives of the claimant, which were housed within the claimant's CEO's offices. The archives are a repository of all initiatives, plans, and objectives executed in the past, present, and future across the claimant's third corporate organizational structure. The essence of which was to ensure continuity and widespread knowledge of such policies, strategies, business plans, and to avoid and mitigate dependency risk on persons. The defendant avers he was responsible for the introduction of innovative and transformative best practice operating systems / mechanisms in the claimant's company, one of which was the depersonalization and institutionalization of best practices in the claimant's operations. With regards to the breach of Clause 3, he averred that since he was not the custodian of the claimant's alleged most sensitive and valued trade secret, he did not breach Clause 3 of the employment letter of April 9, 2018. However, for all classified information relating to the activities of the claimant, he held it in the strictest confidence and for the sole and exclusive benefit of the claimant. He stated further that he did not engage in any business enterprise which has the same business objectives with that of the claimant within 24 months of leaving Halogen Security Company Limited. That the object and business of SETI Limited, formerly called FTSL Limited, is an information technology and software development company which are set out in its memo and articles of association as follows. 1. Information technology and software development, computer ICT and technology, other incidental including but not limited to entering into legal contracts, production, transportation, logistics, acquisition, transfer and ownership of fixed and movable assets locally and internationally, or other such legal acts necessary for the attainment of its objective. Develop a digital marketplace, bringing together supply and demand players using intelligent platforms for efficient transactions. Develop platforms, ecosystems, and social interaction tools for relevant stakeholders and the public. Carry out digital transformation projects, provide AI-powered analytics and technology advisory services, provide technology project management services, develop and deploy hardware and software infrastructure, engage in M&A, JV, and other endeavor to fulfill capability building engagements, and to do all such other things as may be considered incidental or conducive to the attainment of the objects or any of them. That he did not breach the restrictive non-compete obligations under Clause 3 of his employment, as SETI Limited is neither a competitor nor a security service company provider. SETI Limited is an ICT/software development company. Its major objects being IT and software development, computer ICT and technology, providing AI-powered analytics and development advisory services, among others, are not in the same line of business nor a competitor to Halogen Securities Company Limited. Besides, he averred that SETI Limited does not have the operational license, personnel, and competence to operate as an alleged security service provider/company. That the incorporation and business objectives of SETI Limited are distinct from those of the claimant. While the claimant is a security company with trained personnel that provide security services to individuals, SETI is a social impact company amongst others, which connects providers of various services and relies on their expertise and know-how to offer those services to the public. And each of these agreements is based on a collaboration net framework and not competition. That even after tendering his 3 months resignation notice in August 2021, he sought and obtained the approval of the claimant's CEO to focus and complete key projects well ahead of his seminal date. In satisfaction, the CEO approved and consented to his early exit before the expiration of his notice period, having been impressed and satisfied with delivery within record time. He also stated that the collaborative discussions held between Halogen and SETI Limited for potential business alliance was prompted due to its fully developed product and service architecture. Moreover, since they were not in the same line of business or competitors, as both companies have and operate distinct business functions and objectives, that he could not have exposed information to SETI Limited because he was never the custodian of the claimant's alleged business strategies and tools of competitive advantage in the security service industry. And due to the third company structure, he could not have access, let alone expose confidential information. That as a result of the role he played in the discussion, any confidential information or alleged trade business secrets of the claimant within his knowledge remained confidential and undisclosed by virtue of the confidentiality and non-disclosure clause embedded in the MOU duly executed between Front TSL Limited, now known as SETI Limited, and the claimant. That even after resignation, he continued negotiations on behalf of and for the benefit of the claimant, and with the full knowledge and approval of the claimant, who were also in regular communication with him, and the full knowledge of his role at SETI Limited, overseeing the strategic initiatives carried out by SETI Limited in favor of the claimant. That the collaborative discussions were cordial, transparent, and concessions were made available to the claimant. The source code deployed by SETI Limited, its digital solution architecture, as well as user testing, were used by the claimant unsupervised by SETI Limited. It was proposed and adopted in the discussions that SETI Limited would utilize only the claimant for the security aspect of its platform, and equity shares were assigned as a sign and gesture of its intended collaborative business good faith with the claimant. The defendant tendered 8 numbered documents as exhibit, which were admitted in evidence and marked as exhibit D1 to exhibit D8. The certificate of incorporation of SETI Limited, previously called Front TSL Limited, dated April 6, 2022, exhibit D1, memo and articles of SETI Limited, dated 20th January 2022, marked as exhibit D2, resignation handover notes on compendium of strategic project issued to the director, strategies of Halogen Group, exhibit D3, SETI Limited proposal deck to the claimant, marked as exhibit D4, report of the committee set up by the claimant CEO, exhibit D5, memorandum of understanding between Halogen Security Company Limited and Front TSL, now SETI Limited, executed in August 2021, it was marked as exhibit D6, claimant's letter dated March 24, 2023, titled Re Business Alliance Engagement Response Solution, marked as exhibit D7, and certificate of compliance, marked as exhibit D8. The defendant's final written address and the claimant's final written address are all embedded in the body of the judgment. So I'm going to go straight to the resolution of preliminary issues and the court's decision. 2 issues arose during trial. Firstly, the learned defense counsel raised objection to the admissibility of 2 documents. He argued they were not and what is important is that the documents in questions were pleaded. The court was referred to the list of documents. The documents in question were listed as number 1 and number 4 respectively. Learned claimant counsel cited paragraph 3 and 13 of the statement of fact where the 2 documents were pleaded. He called in aid section 12 of the NICN Act 2206 and urged the court to disregard technicality. In agreement with counsel, the documents were admitted and marked as exhibit C1 and exhibit C4 respectively. The court then directed counsel to raise the issue at the final written address stage. The court has noted this issue was not raised by both counsel. In the circumstance, the court would regard the objection as abandoned. On the second issue, during cross-examination, the defendant who testified for himself was asked, "A few minutes ago, you adopted a witness statement on oath and you signed it?" He answered yes. He was asked again, "Did you sign it in your office or in your lawyer's office?" And he answered, "In my lawyer's office." Claimant counsel has argued in his final written address that DW1's witness statement on oath dated 5th April 2024 ought to be expunged, same having not been allegedly signed before the Commissioner of Oaths. The defendant submitted in his reply that the witness statement on oath deposed to on the 5th day of April 2024 was indeed deposed to at the registry of the National Industrial Court Registry and before the Commissioner of Oath, as evidence from the certified records of the court in the affidavit of facts dated July the 16th, 2024. DW1 filed an affidavit of facts to prove that the defendant was at the registry of this honorable court on the 5th day of April 2024 as borne out from the CTC of the attendance records of the court registry, that the deponent who appeared before the Commissioner of Oath on 5th April 2024 to depose to his witness statement on oath is listed as number 9 on the record. Learned defense counsel further argued that the defendant had never appeared before a court or in the court/trial proceedings. He only visited the lawyer's office to brief and give instructions on his defense. He therefore became unsettled and misunderstood the question posed to him to relate to his being at the lawyer's office to brief counsel on the matter and provided a contradictory response. During re-examination, this ambiguity could not be cleared due to the objection raised by Generally, the law does not allow the form of an oath or affirmation to vitiate the oath or statement made under the oath, or allow the absence of oath or affirmation to prevent the admissibility of evidence that should be on oath. See Adejugbe versus Aduloju, citation provided. In fact, Section 4 sub 2 of the Oath Act states that no irregularity in the form in which an oath or affirmation is administered or taken shall 1. Invalidate the performance of official duties. 2. Invalidate proceedings in any court. 3. Render inadmissible evidence or in respect of which an irregularity took place in any proceeding. While by Section 4 sub 3 of the Act, the failure to take an oath or make an affirmation and any irregularity as to the form of an oath or affirmation shall in no case be construed to affect the liability of a witness to state the truth. See Adejugbe versus Aduloju, Supra. Section 13 of the Oath Act requires the deponent to appear physically before a commissioner of oath as the person authorized to administer the oath. See Ashiru versus INEC. There appear to be divergent views on the nature of a witness statement on oath. Some authorities categorize it as an affidavit. Others hold the view that it is part of a party's pleading until it is adopted. Then it becomes evidence. See Ashiru versus INEC, Funtua versus Tijani. Citations all provided. Learned Claimant Counsel was by his question not attacking the capacity of DW1 to tell the truth while in the witness box. His question, though not pleaded, was material to ascertain that DW1's deposition was administered before a person duly authorized to administer oath. DW1 had adopted his witness statement on oath before he was asked the question of where he signed the deposition. The law requires objection to supposed defective witness statement on oath to be raised timeously before it's adopted, as it becomes evidence thereafter. The court held in Registered Trustee of Roman Catholic Mission of the Archdiocese of Onitsha versus Edoziumo, citation provided, that the witness statement on oath upon adoption becomes the evidence in chief of the witness. If there is any objection or concern with the witness statement, such objection should be raised at the time the witness seeks to adopt it. Once it is adopted without objection, it is no longer open to a party to challenge the competence of the witness statement, which has translated to the witness evidence in chief. The implication of adopting an irregular witness statement on oath is that such adoption makes the deposition admissible. In the instant case, the challenge raised by the appellants against the competence of the witness statement on oath is at the final written stage. If counsel has any objection to the regularity of a witness statement, the proper time to raise it and draw the attention of the court to the said irregularity is at the point the witness seeks to adopt same as his evidence. Once adopted, the witness statement transforms to the evidence in chief of the witness, and every objection to its regularity becomes of no moment, and I will therefore not dwell on it further. He continued, if an objection is not radical and does not go to the essence, like jurisdiction, as opposed to mere formal objection, then such an objection must be raised at the earliest opportunity. Otherwise, the party objecting, by failing to do so on time, may be deemed to have accepted the state of things as it was, and may otherwise be stopped by his conduct from raising the objection in a future date. End of quotation. Adopting this holding, I find that this objection not being a radical one, assuming without considering that it is valid, the appellants are stopped from raising them at this late stage of the proceeding. The issue in this case is different, as it is the practice of the registry of this court to require the presence of every deponent before the process can be accepted for filing. Learned Claimant Counsel's question sought to disprove this practice, but the defense has brought evidence through an affidavit that the practice is still in place, and in fact, he was number 9 on the list of deponents that came to file processes on the date he deposed to his witness statement on oath. Section 145 of the Evidence Act permits the court to make presumptions which will be regarded as proved unless the contrary is shown. Section 167 of the Evidence Act also empowers the court to presume the existence of any fact which it deems likely to have happened in the course of events. In the considered view of this court, this affidavit, accompanied with a certified true copy of the list of deponents, has satisfied the court that the practice of the court registry requiring the presence of deponent is still in place, the attempt by the Learned Claimant Counsel to disprove it notwithstanding. In the light of the affidavit evidence revealing the true state of affairs as regards before whom DW1 deposed to his witness statement on oath, I think it is equitable and in the interest of justice to discountenance the Learned Claimant Counsel's argument on its competence or admissibility. Accordingly, the said objection is hereby overruled. I so hold. Now to the court's decision. Now, as regards the case at hand, the locus classicus on the principle of restraint of trade is a case of non-Denfeld versus non-Denfeld, citations provided, where it was held that restraint of trade arises when one or both parties agree to limit their individual freedom to contract, especially their future freedom to freely practice their skill, trade, or profession. The general rule is that all covenants in restraint of trade are void as being contrary to public policy in the absence of special circumstances justifying them. A restraint of trade agreement, whether partial or general, is a restraint of trade, and once the object is to restrict a person's freedom in trade and competition, it is prima facie void. See Herbert Morris versus Sachs Elby and the Nigerian case of Kumulis versus A.D. Leventis Mutus, citations all provided. The crux of the claimant's case is that Nnamdi Meli, in his position as chief corporate strategy, was the chief custodian of the claimant's business strategies, had trade secrets, and tools of competitive advantage in the industry. He therefore breached clause 3 of the contract of employment when sometime in April 2022, he left the service of Halogen Security Company Limited to join and become the chief executive officer of a competitor company known as SETI Limited. The said clause 3 provides as follows: you shall and maintain all classified information relating to the activities of the company in strictest confidence and for the sole and exclusive benefit of the Halogen Group. Also, during the term of your employment and for a period of 24 months after the termination of the employment, you shall not engage in any business in the industry which has the same objective as that of Halogen Group or with any other business or company that may in any way be deemed as competitor of the Halogen Group. End of quotation. The claimant is therefore seeking for a declaration that the defendant is in breach of clause 3 of this contract of employment. Clause 3 has 2 arms. The first arm of clause 3 provides for maintenance of all classified information relating to the activities of the company in strictest confidence and for the sole and exclusive benefit of the Halogen Group. This first arm raises the issue of whether the defendant disclosed classified information to SETI Limited. In other words, did he hold classified information in strictest confidence? The second arm of the clause restricts the defendant during the term and after determination of your employment and for a period of 24 months from engaging in any business in the industry which has the same objective as that of the halogen group or deemed as a competitor of the halogen group. With regards to the first arm of the clause, a court does not grant declaration of rights either in default or admission without taking evidence and being satisfied that the evidence led is credible. See Sky Bank versus Peron Nigeria Limited, citations provided. Lemonade Claimant Counsel argued in his final written address that proving trade secret disclosure often does not rely on documentary evidence. Rather, it is the natural consequence of the breach, a position the law permits where there is sufficient evidence to establish the facts asserted by the claimant. Although documentary evidence, being the hanger upon which oral evidence stands, would have lessened this burden of proof. During trial, CW1 was asked if he had any documentary evidence before the court to prove his statement in paragraph 19 and 20 in his witness statement on oath, to the effect that the defendant has revealed trade secrets and confidential information to SETI, and his answer was, and I quote, "No, I do not have." It is worthy to note that the claimant is seeking for a declaratory relief, which are not granted as a matter of course. They must be proven by adducing credible, sufficient evidence. In Igwe Buike versus Ezo Nwoka, citation provided, it was held that indisputably, in an action for a declaratory relief such as the one hearing, the appellant was duty-bound to prove his claim on the strength of his own case. This is essentially so because declaratory reliefs are not granted on a platter of gold. They are only granted as products of credible and cogent evidence proffered at the instance of the claimant, such as the appellant hearing. See Dumes Nigeria Limited versus Peter Nwakwoba and Colonel Anyaru versus Mandelas Limited, citations all provided. This position of the law was re-echoed more recently by the Apex Court in INEC versus Atuma, that it has been stated in clear terms that the burden of proof on the claimant or the plaintiff in establishing declaratory reliefs to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on the admission by the claimant, where the plaintiff fails to establish his entitlement to the declaration by his own evidence. A court does not grant declaration of rights either in default or an admission without taking evidence and being satisfied that the evidence led is credible. End of quotation. In a bid to determine the alleged breach, the court has evaluated the evidence before it to identify the particulars of the breach. What and how were the trade secrets disclosed to establish a violation of the first arm of clause 3? The first arm of clause 3 is on confidentiality. The general law relating to breach of confidence prohibits ex-employees from using information which can fairly be regarded as a separate part of the employer's stock of knowledge that a man of ordinary honesty and intelligence would recognize to be the property of his old employer and not his own, to do as he likes with it. See the decision of Udoma JSC in the case of Cumulis Leventis Motors Limited, citations provided. It is tried law that he who has said must prove, and that failure to prove averment in the pleading means that they are abandoned. See Olalumi Industries versus NIDB and Ideshaw versus Odia. The non-disclosure agreement as contained in clause 3 of Exhibit C2, the claimant has failed to point out to the court the specific secrets and confidential information, the particulars of breach, the evidence of disclosure that the defendant was alleged to have disclosed, the occasion or date he disclosed it, by what means or mood he disclosed it. There is no evidence before this court. The claimant is speculative and lacking in proof of material facts. What is left for the court to do is to speculate the particulars of disclosure. The claimant did not plead and provide evidence to display one incident where the disclosure of his secret affected her negatively, or how the trade secrets benefited SETI Limited. This the courts have frowned against in a plethora of cases. See Ogaku JCA in Unity Bank versus Rebam Engineering. And I quote, "It does appear to me that the law has been firmly ensconced that a court acts on the evidence before it, and it is not in the place of the court to speculate or make conjectures." End of quotation. All that the claimant stated in his pleading is that Namdi Meli, who was head corporate strategy by becoming the MD CEO of SETI, has now put all the claimant's valued trade secrets at the disposal of SETI Limited for its benefit. These include the claimant's strategic business plans, customer database, market survey reports, pricing methods, operational modules, confidential business information, and other claimant's critical tools of competitive advantage in the security services industry. Reciting this averment in CW1's witness statement on oath does not necessarily discharge the burden of proof placed on the claimant in the light of the fact that the defendant has vehemently denied this allegation. The defendant has denied that he breached his duty of good faith and loyalty. Firstly, his position was that the claimant ran a tiered corporate structure. The custodian of its business secrets were the offices of the CEO and PMO, and these offices were chaired by the group CEO. Even the documents, plans, and strategies were domiciled in the corporate archives, which were housed in the CEO's office. Secondly, even after his resignation, he continued negotiating potential collaboration between Halogen Security Company Limited and SETI Limited. He maintained that he could not have disclosed business strategies as secret because he was not the custodian of the secrets. During trial, CW1 was asked if he was aware of an MOU with SETI Limited known as Strategic Business Strategy. He have replied in the affirmative that there was an MOU with FTSL, which later metamorphosed to SETI Limited, which required FTSL to make substantive investment in equipment, infrastructure, and mobile services, mobile devices for the operation of the corporation, for the operation of the collaboration. CW1 again confirmed that SETI Limited also gave its soft code to Halogen Security Company Limited, and the collaboration was mutual. The court noted with interest that the defendant's handover notes exhibit G3 in its conclusion mentioned outstanding projects and gave some details where some documents were domiciled. Specifically, paragraph VI and V states that all policy documents rest in the archives within the GMD's offices. The defendant also tendered Exhibit G4, which is SETI's Limited proposal deck to the claimant under security coverage. It was noted under cross-examination, CW1 was asked if certain information are domiciled in the CEO's office, and his answer was, and I quote, "It does not mean that secret documents domiciled in CEO's office cannot be replicated elsewhere. We have a server, and you can have access if protocol allows your designation to have access to it." End of quotation. This testimony is suggestive of multiple officers having access to the claimant's server if protocol grants access to such individuals. Meanwhile, at paragraph 5 and 8 of the statement of fact and CW1's witness statement on oath, it was stated the defendant, as the group head of corporate strategy of the claimant, was the custodian of the claimant's business strategies and tools of competitive advantage in the industry. Black Law Dictionary defines a custodian to be a person responsible for safeguarding, a trustee, a guardian, a person entrusted with care to supervise and manage property, record, or assets. By the above definition and description, can the defendant be rightly defined as a custodian of the secret records of Halogen Security Company Limited? This court does not think so. There is no evidence to convince the court that the defendant was the custodian of the secrets of the claimant. From CW1's evidence during cross-examination, it is not for the court to speculate that the defendant was amongst other officials who could access the server to get information if protocol allowed. Courts do not base their decisions on speculation. This is the finding of the court. The claimant also argued that since the defendant is the custodian of the secret information, by leaving the claimant's company, he has disclosed the trade secret of SETI Limited. This argument does not stand on a solid foundation. The claimant has failed to establish what the defendant did. The claimant has failed to establish that the defendant did not maintain all classified information relating to the activities of the company in stricted confidence and for the sole and exclusive benefit of the Halogen Group, and for the reasoning of the court earlier stated, I so hold. For the second arm of clause 3, it provides that the defendant shall not, during the term or after the determination of employment and for a period of 24 months, engage in any business in the industry which has the same objective as that of the Halogen Group or deemed as competitor of the Halogen Group. What the above clause seeks to achieve is to restrict DW1 from engaging in any business with same objective as that of the Halogen Group or deemed as a competitor of the Halogen Group. Trade restraint is defined by Sagi in his book, Nigerian Law of Contract, second edition, at page 427, as, and I quote, "A contract in restraint of trade is one in which a party covenants to restrict his future liberty, to exercise his trade, business, or profession in such a manner and with such persons as he chooses. Prima facie, such contracts are void, but where it can be established that such restrictions are justifiable in the circumstance as being reasonable from the point of view of the parties and the public, they are valid and binding." See also the case of Tank Sale versus Ruby Medical Center, citations provided. In Continental Chemists Limited versus Ife Kandu, citations provided. The court held, and I quote, "After a company is incorporated, the memorandum becomes the charter of its activities and at the same time defines its field operation. Apart from statutory powers, anything done outside the stated objective is ultra vires the company. It is invalid and cannot be ratified by the members." See Ashbury Railway Carriage and Iron Company versus Ritchie, in which Lord Keynes said at 667 that the rules served the dual purpose of protecting both the investors and the creditors, but the rule is applied liberally so that whatever is fairly incidental to the object stated in the memorandum, unless expressly prohibited, is regarded as intra-virus. See Attorney General versus Great Eastern Railway Corporation, citations all provided. In the instant case, the time frame for the restriction is 24 months. It is commonplace that generally all covenants in restraint of trade are prima facie unenforceable in common law. They are enforceable only if they are reasonable with reference to the interests of the parties concerned and of the public. See again Cumulis versus Leventis, Overland Airways and Captain Jam, the Market Research Consultancies Limited versus Mr. Matri, unreported suit number NICN LE/532/2024, the judgment of which was delivered on the 19th of January 2017, and MRS Holdings versus Ibrahim Akar, citations all provided. What this means is that covenants in restraint of trade, in bracket non-compete clauses, are unenforceable unless it is shown to be reasonable, and it is in the party seeking to enforce it that has the onus of proving that it is reasonable. In the instance case, it is the claimant who must show that the non-compete clause in Exhibit C2 is reasonable. During cross-examination, the defendant testified that his educational qualification was BSc Insurance, MBA, professional certification at Chartered Institute of Insurance, London. By Exhibit C2, he is restricted from engaging in a company deemed to be in competition with Haludin Security Company Limited for 24 months. There was, however, no geographical coverage specifying whether the restriction is to Lagos, Nigeria, West Africa, or global. This clause therefore restricts Nnamdi Mele from engaging in any business in the industry which has the same objective as that of Haludin Group for a period of 24 months, approximately 2 years. Is this a reasonable restriction? How is he expected to earn a living? If he is to exit the industry entirely, not forgetting the fact that the claimant is a private security service company, the clause is silent on whether the defendant is restricted only to the private sector or to the public sector as well. In addition, this court is saddled with the responsibility of determining whether the claimant and SETI Limited are engaged in same business with same objective and therefore competitors. The court, in order to determine the objective of the claimant, has to place their objectives side by side to determine whether the two companies are indeed engaged in the same business and in the same industry. Parties are in agreement that Exhibit C2 is a subsisting contract of employment between the parties, and the claimant is seeking a declaration that Clause 3 was breached by the defendant. So to the defendant, the claimant's business is different from that of the company the defendant joined after leaving the employment of the claimant. This court noted with dismay the strategy of the claimant not to tender its memorandum of association, since the core of its matter is whether the defendant is engaged in a business which has the same objectives and therefore competitors, before making a determination whether the claimant and SETI are engaged in the same business. The defendant has argued that the object and business of SETI Limited is IT and software development. Defendant exhibited its memo and articles of association, Exhibit D2, and the object for which the company is established are listed in the body of the judgment from A to K. The claimant tendered his brochure, Exhibit C1, also known as company profile, which gives a comprehensive background about the company, who they are, and how the company works through technology and knowledge, its emergency response framework, its achievements and commitments, its key strengths, its statutory compliance status, and strategic response to the future of security. The object of the claimant is still hazy, as there is no memorandum of association tendered. The court had to resort to the statement of facts, paragraph 1 to 3, where the claimant introduced and described herself as a limited liability company registered under the laws of the Federation of Nigeria and carries on business of security services. The claimant adverts that it is a popular security service company in Nigeria, and its services and products include the following: 1, emergency security response; 2, development and deployment of security and safety solutions for corporate organizations and private individuals; 3, development including security monitors, softwares, security awareness services and protocols; and 4, provision of security guards. In the MOU marked Exhibit C6, the responsibility of both parties are spelled out clearly. For halogen securities and engagement with government security agencies, provision of capacity and capabilities training for service personnel, provision of valid and relevant operational permits for response services from Nigerian security and civil defense corps and other agencies, amongst others. The responsibility of FTSL, in brackets, SETI Limited, is to manage digital ecosystem infrastructure, provision of unique mobile and web service interfaces for each distinct stakeholder, and intelligence reports, etc. Whether or not a covenant in restraint of trade is reasonable is a question of fact and depends on the circumstances of each case. The claimant has the burden to prove its reasonability, which is often determined by reference to such factors as the interest of the parties and the public, the geographical area of coverage, the economic activity covered, and the duration of the application of the clause. See unreported judgment delivered by the President of this court, Honorable Justice B.B. Kanye, PhD, on 11th of July 2018 is suit number NICN/LA/170/2014 between Infinity Tires Limited and Mr. Kuma and 3 others. A non-compete clause is first and foremost a covenant in restraint of trade, and so unenforceable, except it can be shown to be reasonable. The non-compete clause in Exhibit C2 is thus prima facie unenforceable. Like I pointed out, it is the claimant that must show that it is reasonable and hence enforceable. It is my finding and holding that from the object clause of Exhibit D2, the self-description of the claimant in the statement of facts and witness statement on oath, a comprehensive reading of the memorandum of association, a comprehensive reading of the memorandum of understanding, which is Exhibit C6, and the two companies Exhibit C6. The two companies are both in the security sector, they're rendering different services to their clients. From the MOU tender, this court is convinced that the claimant is a private security company regulated by the Nigerian Security and Civil Defense Corps, and the Ministry of Interior certifies it before it can operate in Nigeria. This is due to the peculiar services it renders in a private capacity in the security architecture of Nigeria, while the defendant is an IT, computer, ICT, and technology service provider and into software development. The strategy of not tendering the memorandum of association of the claimant has left the court with no option but to speculate the specific objects of the claimant, which the courts have frowned against. As for the restrictive clause, as earlier mentioned, the agreement on restriction of the defendant is open-ended. It will be unreasonable and permanently against the interests of the defendant. Therefore, I further hold that the two arms of the clause are not enforceable. Neither are they binding on the defendant in this case. In view of the findings above, the declaration that the defendant is in breach of clause 3 of its contract of employment with the claimant dated 9 April 2018 is hereby declined. Relief 1 fails. The claimant is also seeking 50 million naira only, being general damages for breach of contract. General damages are those damages that the law presumes are flowing from the wrong complained of by the victim. See Mbata and another basis amongst the citation provided. The first relief being the foundation, and having failed, relief 2 is declined and it is dismissed. The claimant is also seeking 2 million as cost. Authorities are bound that the award of cost is entirely at the discretion of the court and that costs follow the event of litigation. The award of cost involves a judicial discretion which must be exercised on fixed principles that are called with rules of reason and justice, and not according to personal opinion or sentiment. In view of the circumstances of this case, I make no order as to court. Judgment is entered accordingly. Signed. This is the judgment of the court.
My Lord, we are grateful for my Lord's very well considered decision. My Lord, this is a very good decision and a good way to end the year. My Lord, we're indeed grateful. My Lord, cost follows events. And my Lord, we think that the defendant is entitled to costs. The claimant haven't lost this case. My Lord, we shall be asking for cost of 1.5 million naira only. My Lord, we are grateful.
My Lord, we are grateful. We must appreciate this court for a well-considered judgment. We are grateful to this court. We'll be opposing to cost, my Lord. Like he said, cost, there's totally no need for the award of cost in this particular judgment. My Lord has already given his well-considered judgment and has seen no need for cost. In that, we'll be opposing seriously to cost, my Lord. That's the position from the claimant.
Well, the judgment has been read, and I recall that in paragraph 108, the claimant is seeking 2 million naira as cost. Authorities are bound that the award of cost is entirely at the discretion of the court, and that costs follow the event of litigation. The award of cost involves a judicial discretion which must be exercised on fixed principles that are called the rules of reason and justice, and not according to personal opinion or sentiment. So, in view of the circumstances of the case, I make no order as to cost.
As a court, please.
That's the
Thank you very much, my Lord.
Yeah, my Lord, we are grateful. My Lord, just for the record of the court, my Lord, Emeka Opara also appears with me. Then I forgot his name in the first place. Emeka Opara Esquire also appears with me. Just before.
Opara, is it OKP or OPARA?
OPARA.
Again?
Emeka OPARA.
Okay.
Yes, my Lord. Emeka's name comes before Olusegun Akeju. My Lord, we are grateful.
I'm grateful to the court.
All right, thank you.
Thank you, my Lord. But we wish my Lord a very good holiday.